The Honourable Opposition House Leader is rising on a question.
Thursday question?
Great to share time with you.
Okay.
Let's go ahead.
Thank you, Mr. Speaker, and again, very glad to see you in the chair. Hope you're getting your strength back. You sound like it. You're doing a good job keeping everybody in good spirits here. Mr. Speaker, before my question, there are a couple of issues that I want to bring to the attention of the Government House Leader. Number one is that we are requesting a take-note debate on the issue of food security, which is having a significant effect around the world, as you know, as a result of many geopolitical issues. The second thing is a request to split Bill C-21, Mr. Speaker, so that we can work on victims and the protection of victims in domestic violence. The third thing I would say, Mr. Speaker, is that there has been significant concerns among stakeholders and advocates right across the country on Bill C-11, and we are seeing some draconian measures that are being proposed by the government to deal with that piece of legislation. So I'm concerned about that. Now, before I ask the schedule, Mr. Speaker, I'm wondering what the Government House Leader's plan is to effectively silence the voice of millions of people who voted for opposition MPs in this place, and furthermore, what his plans are to contribute to a further decline in democracy in this place over the course of the next week. Thank you, Mr. Speaker.
The Honourable Government House Leader.
Well, thank you very much, Mr. Speaker. And the cornerstone of democracy is voting and showing up to this place and participating, and that's, of course, what we do. And whether or not it's on C-11 or C-21, there'll be an opportunity, obviously, to continue debating this legislation. And on C-11 specifically, there were 9 days at committee. There were many days at second reading. We have opportunities at third reading. It's going to be going to the Senate, and it's in taking essential action to protect Canadian creators and also Canadian heritage. So we're proud to support that bill, and part of the thrust and party of this place is that sometimes we disagree. That's not a representation of a decline of democracy. It's proof of it working. Mr. Speaker, this afternoon we will continue with report stage C5 respecting mandatory minimums. Then, Mr. Speaker, we'll call second reading of Bill C-21, the firearms legislation. Tomorrow we will debate government motion number 16 regarding proceedings for Bill C-11, as I was mentioning, the Broadcasting Act. When we return next week, we will focus on this government motion debate and continue our work on Bills C-5, C-11, and C-14 concerning electoral representation. Thank you, Mr. Speaker.
Orders of the day.
Ordre émanant du gouvernement, projet de loi émanant du gouvernement commune, resume consideration of report stage of Bill C-5, an act to amend the criminal code, and on the motions in group number 1.
Reprise du débat.
Resuming debate.
Member for Sherwood Park, Fort Saskatchewan.
Well, thank you so much, Mr. Speaker. I appreciate the opportunity to speak today on Bill C-5, a piece of government legislation aimed at reducing sentences for crimes, including very serious crimes, such as sexual assault, kidnapping, and weapons trafficking. Now, many of my colleagues on this side have ably spoken to the core issues raised by this bill, in particular the question of whether lower sentences and conditional sentences are appropriate for these kinds of very serious offenses. I'm not going to repeat their arguments today. Instead, I want to respond to what seems to be the main rationale that the government is using to defend this legislation. Comments from government members on this bill have generally avoided reference to the substantive measures in it, and in particular to the changes to sentences for serious violent crime. It is revealing that members of the government do not want to actually talk about and defend their decision to lower sentences for serious crimes. The government's attempt to justify this bill has focused on noting, correctly, how the problem of systemic racism leads to the overrepresentation of Black and Indigenous people in our justice system, but then claiming incorrectly that this bill somehow addresses that problem. It is a fact that there is nothing in this bill to address any kind of racism. It contains no measures respecting anti-racism training, no measures to discourage racist behavior, no funding for communities that are victims of racism, and no special procedures to protect the rights of historically marginalized communities when they encounter the justice system. In fact, while the government evokes the challenges facing Black and Indigenous Canadians every time this bill is discussed, the bill itself does not even contain the words Black or Indigenous. A quick search of this bill shows that the bill actually says nothing about race or racism either. This is a bill that is not about, that says nothing about racism facing Black and Indigenous Canadians, and yet the government's justification for this bill is to claim that it does something that it demonstrably does not do for those communities. Now, the government purports to believe that lowering sentences overall will somehow address the disproportionate representation of certain minority communities in the prison population. This seems on the face of it to betray a certain misunderstanding of how fractions work. Changing the average sentence for a particular crime from, say, 4 years to 3 years does nothing to change the proportion of people from a particular community who are serving time for that crime. Reducing overall sentences does nothing to change the proportion of those in prison who are from a particular community. Any mathematically sound strategy for reducing overrepresentation would obviously need to reduce sentences for the overrepresented group only, or to increase sentences for the underrepresented group only, or, best of all, to identify and confront the root cause of that overrepresentation in the first place. But reducing sentences for both overrepresented and underrepresented groups by the same proportion doesn't actually address the phenomenon of over or underrepresentation. Now, in fairness to the government's position, it's not always quite that simple. It may be that there are certain crimes where the overrepresentation of certain communities is greater than other crimes. For example, in the case of drug crime, there may be certain kinds of drugs that are more prevalent in some communities than others. There are cases and places where offenses involving drugs that are more common in minority communities have carried more severe sentences than offenses involving equivalent drugs that are more common in majority communities. And in such cases, measures to equalize the sentencing for equivalent kinds of substances that are more or less common in different communities would be a step towards addressing the problem of overrepresentation. However, that's not what Bill C-5 does. Bill C-5 does not make these kinds of granular adjustments. Rather, Bill C-5 is a relatively short bill that lowers sentences for broad categories of offenses. I see no reason why these reductions in sentencing parameters would impact overrepresentation in any way. And perhaps I can make this point clearer with an analogy. We know that Black and Indigenous people are overrepresented in our justice system and also underrepresented in our post-secondary system. We need to address the way that systemic racism leads to overrepresentation in penal institutions and underrepresentation in institutions that often lead individuals to positions of power and privilege. So imagine...
Just a second. There is a call for order. Yes, Madam Speaker, with all respect, we are hearing that the interpreters cannot follow. It is going too quickly. I know he's hyperactive just like me, but out of respect for the interpreters, could you please go a little bit more slowly?
I know that we've raised this in the past, so I'm just wondering if the honourable member can slow down a little bit to ensure that every parliamentarian hears what he's got to say. It is very difficult for interpreters to be able to interpret properly if the speed of the speech is too quick. I'm not sure if the honourable member has provided a copy of his speech to the interpreters. If not, again, I would remind all members to please do so. It is something that we hear on a regular basis. It is very difficult for interpreters to be able to follow the speakers in the House. The honourable member.
Speak to the same point of order. In this case, I did provide my notes in advance to interpreters, and I have a great deal of respect for what they do. It is a little bit of a challenge when members want to deliver a certain amount of content in a limited time frame, and we're under time allocation, of course, as well. But it's a question of, I think, the ability of members to need to convey ideas in the limited time frame. So
again, unfortunately, we do have to ensure that all members are able to understand what is being said in the House. Though it's not unfortunately, I mean, that is what we need to do. And the honourable members generally know how much they can put within a 10-minute time frame or a 20-minute time frame. So, you know, it's not about rushing. It's about making sure that the speech is being delivered as it should. So the honourable member for Sherwood Park, Fort Saskatchewan can continue.
Thank you, Madam Speaker, and I hope that the interpretation is able to deliver the content, but I mean, I'm entitled to give my speech as a member, and I hope that, given that I provided the notes in advance, that this issue will be addressed. Anyways, so I imagine if there's, I was speaking about underrepresentation in post-secondary institutions. Now, Madam Speaker, I imagine if I were to propose that the way to reduce underrepresentation of Black and Indigenous people in universities was to reduce the length of degree programs, we would recognize that didn't make sense. If I were to claim that reducing the length of an undergraduate degree from 4 years to 3 years would address the underrepresentation of people from particular communities, we would recognize that that was obviously absurd, because changing the length of a degree program does nothing to change the proportion of people from different communities who are there or to address the underlying factors that lead to underrepresentation. But what is true for the length of degree programs is also true for the length of criminal penalties. That changing the overall length does not change the proportions. And now, Mr. Speaker, I want to now speak about the relationship between racial justice, and judicial discretion. Bill C-5 lowers sentences for a variety of crimes, including very serious crimes, and it does so in part by widening the window for judicial discretion. Now, I believe that judicial discretion, as well as the setting of benchmarks and parameters by the legislature, are both important elements in sentencing. In a democratic society, it's right and important for the people's representatives to deliberate and give direction about the kinds of sentences that they see as appropriate for certain categories of crimes. It is also important for judges to be able to exercise their discretion in accordance with the particular facts of each case, using the parameters and formulae established by the people's representatives. Now, one key function of sentencing parameters set by the legislature is to help ensure relative consistency. If the facts of two different cases are virtually identical, then the sentences should also be virtually identical, even if the two defendants go before two different judges. The most effective way to ensure that two different judges in two different courtrooms apply a similar sentence to a similar set of facts is to have something like sentencing starting points set by the legislative branch. Too much individual discretion leads to inconsistent decision-making. Now, one risk of giving too much discretion to judges is that they, like all of us, have unconscious bias. A possible partial explanation for the overrepresentation of Black and Indigenous people in prisons is that the unconscious bias of judges leads to relatively longer sentences being applied in cases with Black and Indigenous defendants. Now, to be fair to judges, I don't know for sure if that's the case or not. But insofar as parliamentarians regularly identify the presence of systemic racism and unconscious bias made in virtually all other institutions, it seems at least consistent to acknowledge that unconscious bias impacts the decisions of judges as well. And if that is the case, then widening the range of judicial discretion, as C-5 does, actually risks exacerbating the problem of overrepresentation by allowing more space for subjective determinations based on how a judge evaluates the character and motivation of a defendant. Relying more on the work of legislatures to establish that a certain type of crime should carry a certain type of sentence in general reduces the range of difference that could be informed by unconscious bias applied to individual cases. And this is not necessarily a defense of the idea of mandatory minimums as such, but I simply want to point out that insofar as unconscious bias leads to differential outcomes when a decision maker has broad discretion, a law which broadens the range for that discretion is more likely to increase than decrease the problem of overrepresentation. Now, I suspect many members of this House will be familiar with the iconic opening of the Godfather trilogy. It's a scene about criminal justice and also about racism. The character Amerigo Bonacero, a Sicilian immigrant who had long trusted the American justice system, is seeking justice for a daughter who was violently beaten by two privileged young men. The racial element implied in the film is clearer in the original novel, with Bonacera noting that the parents of the perpetrators in this case were, quote, his age but more American in their dress. The judge opts to be lenient to the perpetrators, saying, quote, because of your youth, your clean records, because of your fine families, and because the law in its majesty does not seek vengeance, sentence to be suspended. So, Speaker, this injustice, the exempting of two young men from the consequences of their crime because of their so-called fine families, leads Amerigo to lose faith in the legal system and instead rely on the mafia to get what he considers justice. This is fictionalization, of course, but it is compelling because it is very real to the circumstances and experiences of many people. The judicial discretion creates the space for preferencing those whose experience and background the decision maker identifies with. And in this case, drives a further wedge between a minority community and the state, because Bonacera sees how the system is less likely to have the back of a person who comes from his background. And this raises a critical question. What does this bill do for Black, Indigenous, and other minority communities who are victims of crime and who want the police and courts to be present and consistent in order to protect them and their families from crime? What does Bill C-5 offer them? Nothing. In fact, worse than nothing, because it does not actually address the real problem of racism. It does not address differential outcomes, and it makes every community less safe by causing the early release of serious violent criminals from any and all backgrounds. And Madam Speaker, one more point I want to make. Black and Indigenous people are overrepresented in the prison population. Another group that is overrepresented in the prison population is men. Men actually account for over 90% of adult admissions to federal custody. So that's a very significant overrepresentation problem. That becomes even more striking when you overlay statistics for race and gender. Indigenous women make up about 2.5% of the total population and 3% of federal prison admissions. That's relatively close. Statistically speaking, the phenomenon of Indigenous overrepresentation in prison is overwhelmingly a problem of the overrepresentation of Indigenous men. Over 25% of total federal prison admissions are Indigenous men. So clearly gender as well as race has to be part of the conversation about overrepresentation. And this raises challenging questions. Does our justice system have a problem with systemic sexism? How might the government go about trying to address the overrepresentation of men in the system? I don't have time to answer those questions, but what is clear is that C5 does nothing to address the issue of overrepresentation of particular communities. The bill itself makes no mention of the issue of overrepresentation or racism, and it contains no measures which target those problems. Reducing sentences for serious crimes makes our communities less safe and makes victims and potential victims of all races and from all communities more vulnerable.
Questions and comments? Questions et commentaires. The honourable for Kitchener Centre.
Thank you, Madam Speaker. I was listening to the member's speech. In it, he purports that mandatory minimum penalties do not contribute to over-representation of Black, Indigenous, and racialized folks across the country. That is not the opinion shared by the Black Legal Action Centre, the Canadian Association of Elizabeth Fry Societies, Women's Legal Education and Action Fund, who have called for the repealing of all mandatory minimum penalties for exactly that reason. What does the member have to say to experts like these?
Member Sherwood Park, Fort Saskatchewan.
Well, thank you, Madam Speaker. The member identified a number of stakeholders who have a particular point of view, and I don't doubt that the committee heard from a broad range of stakeholders with different points of view on the bill. But my point was fairly specific. It was simply to say that when you broaden the range of discretion for decision making in a situation where the decision maker may or likely does have unconscious bias, broadening the range of discretion for that decision maker doesn't make the problem better, it makes the problem worse. So we can talk about alternative mechanisms like sentencing starting points or clear parameters for judicial decision making. But in the absence of those things, when the government proposes a bill that widens the latitude for judicial discretion, and there are concerns about unconscious bias, it doesn't make any sense to me to say that that's somehow going to address the problem of overrepresentation. It isn't.
Questions and comments? The Honourable Parliamentary Secretary to the President of the Treasury Board and to the Minister of Emergency Preparedness.
Thank you very much, Madam Chair, for acknowledging me. And I was listening very intently to the member opposite on his comments of Bill C5, and I had the opportunity to sit on the Justice Committee where the bill was deliberated, and we heard from witnesses after witnesses who talked about the negative impact of mandatory minimum sentences on those especially who are of indigenous or racialized background. But I want to take the point around discretion. In the member's opinion, isn't it better and more appropriate for judges who are presiding over cases who have the benefit of listening to detailed evidence and cross-examination to be able to determine as to, if found guilty, as to what's the appropriate sentence will be, as opposed to legislators preordaining a mandatory minimum sentence when we do not know what the circumstances may be?
The Honourable Member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. Clearly, judicial discretion and parameters set by legislatures both have a role. The question of what is the appropriate sentence for a particular category of crime is a philosophical question. It's a moral question. It's something that in the democratic society, the legislature should, in general terms, pronounce on. The question of to what extent those broad parameters apply to the particulars of a case is a question of the facts of the case at hand, a question that requires surgical discretion that responds to the particular factors. Of course, that's why the legislature shouldn't say always in every case this particular offense carries exactly this offense. But it's legitimate for the legislature to say in general, we wish to express that we think that this type of crime proportionately accords with this type of sentence.
We have time for a brief question. L'honorable député Rivière-des-Mille.
The honourable member from Rivière-du-Mille. Thank you, Madam Speaker. Here's my question for my colleague. Is my colleague aware that incarceration for minimum sentences for minor offenses, such as drug-related offenses, is he aware that that doesn't actually lead to good results? In fact, it doesn't do anything. There's no empirical data. There are no studies showing that these mandatory minimums are helpful.
Just under a minute.
Madam Speaker, we need to be very clear that there are no mandatory minimums for personal possession related offenses of drugs. Our party does not support mandatory minimums for personal possession for personal use offenses. We do believe that it should be against the law to possess drugs for personal use, but we don't support mandatory minimums in those cases. I'm concerned about the fact that this legislation reduces sentences for very serious violent crime like sexual assault, kidnapping, and weapons trafficking. Those are clearly very different cases from the cases the member spoke about.
Reprise le débat. L'honorable député.
Resuming debate, the honourable member for Rimouski-Nejet, Témiscouata-Les Basques.